Thank you and welcome to the second in-person meeting of the MSBA Health Law section. We are having a joint meeting tonight with the University of Maryland Francis King Carey School of Law to welcome and talk about things like healthcare and AI. My name is Christopher Dean. I'm the Health Law section chair. To my left is Eleanor Chung. She is the current vice chair. And then we have various section council members in the audience. If you're in section council, you want to stick up a paw and raise your hand. I see Randy, I see Robin, I see Connie, I see Shelley, I see Dan. So these are our leaders that are here for the health law session. If you have questions or things you'd like to talk about or share, please do so, reach out to them. And because our goal is to try to get members re-engaged in the health law section. And the only way we can do it is to listen to what you're telling us as to what you'd like us to do in the upcoming year. This is our last in-person meeting for this year. We'll have at least 2 in-person meetings next year, as well as what I call the lunch and learn format, where we're having an online presentation for people who like to work at their desk rather than come to an in-person meeting. Before going any further, I want to thank a few people to make this happen. I mean, this looks like it is a fantastic event. It takes a lot of effort and a lot of energy to get it to happen. Thank you to Dean Hoffman, Rebecca Hall, Gihan, Robin Siegel, and Trisha Rust. Took a lot of emails, a lot of, hey, can we do this? When can we do it? Can we do it now? Why can't we do it now? Can we do it next week? Can we do it last week? Can we get this information out? It's a lot of moving parts. They were very patient, and all of their work together got this to where we are right now. And so thank you to them. I have a couple of matters of business, and then we'll proceed to the presentation. The business matters, we have a couple of old business items and a couple of new ones. The old business goes back to our first meeting. We talked a little bit about how this coming year, we're going to have a Health Lawyer of the Year award and a Young Health Lawyer of the Year award. The Health Lawyer of the Year award will be sponsored by Gordon Feinblatt, and the Young Health Lawyer of the Year award will be sponsored by Epstein Becker Green. We'll have more details to come in January. We will promulgate that out both verbally, electronically, and via, I think, if Tricia, you can prove me wrong from that, there'll be a new MSBA communication platform soon? Yeah. Yes. Okay, so we'll have those details out in January. We'll be looking for nominations and make an award at an appropriate date and time. So please look out for that. We also have 2 items. We'd like to set up 2 working groups. The first is the AHEAD model working group. And many of you know this, in Maryland, we don't pay our hospitals like Medicare does normally. We have a special program. It used to be called the Maryland Waiver, then it was Maryland Total Cost of Care. The program that's in current, that ends December 31st. The new one is the AHEAD model. It starts January 1. The state just signed the agreement with CMS. The working group is designed to facilitate conversation among health lawyers about how this looks moving forward in the future. I don't think we have a aim in mind. We're not trying to lobby. We're just trying to facilitate collaboration discussion so that we can all approach the AHEAD model together and make it work for the health law community. That's the first working group. If you're interested in joining that group, please contact me by email or somehow fashion later on and let me know. The second working group is we're going to form a working group about hospital involuntary admissions and discharges. And so there's a need in the state to at least collaborate what is the best way, the most meaningful way to both handle the involuntary admissions and also discharges. Sometimes there are patients in hospitals who need care, deserve care, but at the end of the day, they're not willing to go to get care, but there's an involuntary admission process. And there's also a point in time, sometimes you have patients who are in beds who've been there for a long time, and perhaps they don't need the care, but they have nowhere else to go. And so those are 2 uniquely distinct problems in a population that I think as a working group, we can probably come up with some kind of collaborative way to help work through those problems in a meaningful way. If that work group interests you, also please contact me. We'll be setting up, hopefully, both these working groups in January of next year.
Christopher?
Yes.
Will those be mostly Zoom meetings to be in that group, or will they be in person?
I plan on them being Zoom meetings. Unless you'd like to meet in person, then I'll adjust to you.
I was only asking since I'm a snowbird and won't be here.
No, I think they'd be remote based.
If you want to go to Chris's office, none will be in person and remote.
No, I got a ticket. I'm not going back.
All right, fantastic. I told everyone that I would start the presentation by 6:15. If I didn't, they could kick me. It's only a few minutes to 6. We'll start the presentation now. So I have bios here for our two speakers. I have Alap Shah and Eleanor Chung. I'll be honest with you, I hadn't met Alap before the meeting started. He's a very energetic, very charismatic speaker. I think you're going to enjoy listening to what he says, to be very engaging. Eleanor, as many of you know, is part of Section Council. She's a fantastic attorney, young attorney, very, very well regarded. But Alap is the co-chair of the Epstein Becker Green Artificial Intelligence Practice, using a tech-savvy, solution-oriented approach to definitely guide clients through complex and ever-evolving AI, privacy, cybersecurity, medical device, interoperability, digital, could you pick longer words? Interoperability, digital health, telehealth, and other laws and regulations. He represents providers, payers, biopharma companies, health information technology companies, AI companies, data analytic companies, health information exchanges, and other innovative companies to build and maintain trust in the healthcare ecosystem. Eleanor is a litigator, advisor, and creative problem solver for healthcare and life science companies. She is particularly adept at advising clients on issues regarding artificial intelligence, information blocking, and the liability of healthcare professionals. She's an associate at Epstein Becker Green and also our vice chair for this year. Please welcome both Eleanor and Alap.
Hi, everyone. Thanks for attending. Thank you, Chris, for the warm introduction, and thank you to the MSBA for having us here. And thank you for to the University of Maryland for hosting us today. It's my alma mater as well as Eleanor's. We're really happy to be here to talk with you today. Before we get started, I just want to say that we want this to be an open dialogue. Artificial intelligence is obviously top of mind for so many of us, and we want to make sure we're really engaging you with content that's meaningful to you. So if you have questions, comments, experiences you want to share, please raise your hand. We're happy to take those. We'll also have time at the end for questions as well. So today, we're going to talk to you about AI in healthcare in particular, and we'll talk about the risks associated with AI in that context, the regulations that are currently in flux and evolving, give you a grounding in that, as well as how do we think about governance in the context of artificial intelligence as it gets adopted and developed in the healthcare ecosystem? It's a lot of ground to cover, and let's make sure we can click on the slides. Okay, so this is us. As Chris mentioned, I sort of live at the intersection of law, policy, technology, and data. That's what I think about all day, every day, and AI really brings a lot of that together. So it's an exciting area of practice. I'm so glad to see some young folks in the room who, this is the kind of practice where you can get in the ground floor, become an expert, and make it your practice probably for the next several decades. So I encourage you to think about that and see how AI might fit into your practice. For those practitioners that are out there who have been doing this for a long time, I would say buckle up, because artificial intelligence is going to change the way law practice happens as well. So start thinking about how you might use that in your practice moving forward as well. Eleanor, do you want to say a few?
Yeah, I just want to say how exciting it is to be here. And that, again, I was a student here and I became interested in AI while being a research assistant for Professor Frank Pasquale, who was working on his book, New Laws of Robotics. And that's how I got in on the ground floor. And it's really a dream to be here presenting on these issues with my mentor at EBG. So thank you for having us. Yeah. Okay, so this is our agenda. We're going to go through AI market trends, current uses of AI risks, litigation, the federal landscape, the patchwork of state AI regulatory landscape, and ideas for effective AI governance. And generally speaking, Alap will talk about the technology and what one can do beforehand, and then I talk about when things go wrong and the litigation aspect of AI.
So it's a lot of ground to cover. We do have a little bit of extra time. Thank you, Chris. But let's start from the beginning, okay? A lot of people throw around the term AI, and unfortunately, it's actually poorly defined. There isn't really a common understanding of what that term means, and we're starting to see some definitions come into focus, especially in the healthcare arena. So I'm putting a couple of these up here for you to look at. I'm not going to read through them, but I want to make sure you're aware that there are a couple of one statutory and then one sort of sub-regulatory definition. But, essentially it's computers doing things that humans usually do based on learning that we provided. Of course, AI can do things at sort of a scale and speed much faster than humans can, and that's sort of the elegant nature. But I will say that regardless of what the definitions are, when we think about AI and risk management, we have to be very, very granular about that. And that's going to be involving what is the AI technology we're talking about, because there's lots of different flavors of that. There's machine learning, there's large language models, there's optical character recognition, there's deep learning, there's neural networks. The list goes on and on. The second part of that is, what is the use case? How are we applying whatever that technology is? And that will start to drive the discussion about what risks may be foreseeable and what risks need to be managed. We're going to talk about some general categories of risks later, but when we think about AI, we have to be a little bit more precise than just the blanket term AI when we think about how to manage risk. Here's one category we'll talk about, generative AI, because it's something that's really hot right now. Think about ChatGPT, Google Gemini, a number of other tools like Claude. Some of these are text-based, some of them are image-based, and some of them are audio-visual. How many of you, by show of hands, have used something like ChatGPT? Yeah, pretty much everyone. How many of you have used an image generator, something like Midjourney? So few of you, but increasing amount as well. What's happening over time is you're starting to see these things come together into what we call multimodal AI, where you may have a chat-based prompt, but it's actually going to be doing text-based work, image-based work, and audiovisual. This is what Hollywood is clamoring about, because when we bring all this stuff together, you can literally create a movie by prompting something like ChatGPT. And then another layer on top of this is people are starting to create what we call agentic AI, where you start to lace together various components together in a workflow. So it can do a number of different things once you sort of put that workflow together. That's going to start to really challenge the notion of how we operate day to day in the healthcare arena and life sciences arena. So think about all these different things and how they're going to impact various things in healthcare. And the other thing I'll sort of start with as a foundational matter is AI requires a lot of data for training. It's only as good as the data that goes into it. And so we're thinking about high volume data, high veracity data, and high velocity. Continue to have data go through these things to develop the AI and train it appropriately to do what we anticipate these AI are supposed to do. Now, if you look at the world that we're living in and you look at the largest market cap companies, you see this article, I love citing this from The Economist, and it's several years old now, but it still rings true. No matter what company you're looking at, whether it was a search engine, whether it's a software developer or an online marketplace, at the end of the day, these are the most valuable companies in the world. And they postulated that was because of the data that they were generating. I will postulate now that it's actually because all the data they've generated over those years has now led them to be artificial intelligence companies. And that's powering the engine of these economies, and it's going to start to power healthcare over time as well. Healthcare is not unique, and we're already starting to see that happen. So let's talk a little bit about what is happening in healthcare. There's a whole bunch of ways that AI is creeping into the healthcare ecosystem and life sciences ecosystem. And this is in part over the last 20 years, we've rapidly digitized in healthcare by adopting electronic medical records and starting to make interoperable systems. So data started flowing on a digital basis across the ecosystem. People said, okay, well, we have all the data at our fingertips now. What do we do with that? And so we started to have all types of clinical and non-clinical applications powered by that data. In radiology, at the top of that diagram, that's one of like the crowning achievements with respect to AI. We use optical character recognition and other sort of image recognition software powered by AI to detect anomalies in radiological scans. The literature is pretty clear that AI tends to outperform human clinicians and has done so time and time again. And we're talking about like 97% accuracy. Also detection of disease well before human radiologists will be able to detect on a human read. So that's one where AI tends to be in the workflows. It's pretty ubiquitous at this point. Some of these other examples, more nascent. So we're starting to see AI in patient engagement. Next time you try to schedule an appointment at the doctor's office, you may be talking to an AI or a chatbot. You may be online trying to schedule something, and guess what? It's not actually a human talking to you. It's probably an AI. We're seeing a lot in clinical decision support generally, not just in radiology, but with respect to early diagnosis and detection of disease. These things are making their way into workflows in electronic medical record systems. But we're also seeing it in non-clinical applications. One of the big ones is revenue cycle management. Everyone wants to get paid. I think Chris mentioned the HEAD program. That's about getting paid. We're seeing AI being embedded in revenue cycle management software so that we can crank through pulling the right information out of medical records, abstracting it into claims, and then submitting those claims to get covered. Now, the flip side of that is we have payers who Eleanor will talk about a little bit later, who are also using AI to do claims review. And in certain cases, there have been disputes around denial of claims because of prior authorization review using AI. So we have this sort of AI versus AI thing happening as well. So just to give you a sense, that's sort of what's happening. Now, when we think about AI in healthcare, I always ask people to think critically about, vendors will tell you it's gonna solve all your problems. It's better, it's faster, it's cheaper. Let's use AI to solve the problems in healthcare. But like any old adage in business, you can only get two of the three: better, faster, cheaper. I would argue faster, probably. Cheaper, getting there over time, it will likely be cheaper. Better is the real rub. In certain contexts, like the radiology context, things have gotten better. In other contexts, we see that there's still a lot of problems with the way AI performs. And so we have to be very careful about governing that risk over time, because we want to make sure that we, reduce risk for organizations that we support and counsel, oftentimes with patients at the end of that road who would suffer. So let's talk a little bit about where we are in terms of governance. So if you look at organizations, this is a little bit dated, but I'll boil it all down for you. Regardless of the sector and the size of organization, they were asked, are you using generative AI? And a lot of them said, not sure, maybe. And then they asked, do you want to use it? And all of a sudden, everyone's like, yes, I want to use it. There's a FOMO moment happening here in healthcare. No one wants to be left behind. Everyone wants to gain the efficiencies and other power that AI might bring to these organizations. So everyone's raising their hand and said, yes, I want to adopt. So now we juxtapose that phenomenon with what's actually happening from a governance standpoint. So when asked, do you have a system-wide governance policy to deal with this? 65% of those organizations said no. And then 19% said no, but we have some other policies that may cover it. So the vast majority of organizations are woefully unprepared from a governance standpoint. Same for generative AI as well. So there's a gap between wanting something and then being able to actually effectively manage the risk of having that AI in your organization. Yeah.
So this slide is a jobs bill for lawyers in healthcare and not.
It is.
Because we are experts in policies, and process, and risk management.
That's right.
So AI does away with all the lawyers' jobs. It'll just be AI arguing about it.
Yeah.
Get closer to the mic, please.
Oh, sure. Can you hear me?
Yeah.
Yeah. Okay. So
Oh, there we go.
So yes, this is a good roadmap for anyone that's thinking about managing risk in AI. This is something that healthcare organizations are, grappling with at varying degrees of sophistication and maturity. Some will be ahead of the curve, some will be behind the curve, but at the end of the day, everyone is trying to solve for this problem in some way. And so we'll talk a little bit later in the presentation about what some governance steps might be for an organization to think about and how you might be able to assist them. So let's talk a little bit about the risks. Do you want to kick us off?
Yeah, sure. So anytime you pick up a newspaper, you're going to see a headline about AI, especially in the context of healthcare. And one thing to consider is there are a few industries that actually call for self-regulation, and healthcare is one of them. Here's an example where AI developers are the ones also saying that they'd like to governance to tell us how to do it responsibly. Case in point here, Anthropic CEO is asking for more regulation. And another prominent example is with CRISPR GPT. I know when I was in school here, Professors Hoffman and Rothenberg were doing work with CRISPR and genomic work at NIH. This has the potential to identify genes responsible for melanoma. It can reduce error by checking researchers' work and increase accessibility of the tool to a broader range of scientists. So we have this incredible device where science are asking for regulations and ones that are consistent within the US and internationally. So while industry is calling for regulation, at the same time, we kind of have this abundance of regulation with states promulgating their own laws. We have some federal guidance, and then we also have the European Union AI law. The EU AI law, some call it the Brussels effect, whereby it sets the floor. So if you want to do business abroad, you have to meet the European standard. And we also see states adopting some of the European standard as well, which I'll talk about a little bit later on. Ultimately, it is all about trust, and humans don't trust things we cannot control or understand. And again, that brings me back to Frank Pasquale's book, The Black Box Society. Like, what is happening in the black box? Is the AI explainable? Do we know when and where it operates? Can we understand how the AI produces outputs? Can we justify the results produced by AI? This slide in general contains the highest level questions we should be asking about AI. I won't bother reading them all.
So another dimension we need to think about, like I said earlier, about data being so important for AI to be properly functioning, is what happens when the data going in to develop an AI or to use an AI is flawed in some way. And we have this garbage in, garbage out phenomenon. Essentially, an algorithm, an AI algorithm could be biased because of the training data you send into it. And we have a really, arguably poor starting point when it comes to healthcare. Because if you think about historical clinical trials data, which is a huge component of AI training in the clinical context, we know the literature is very clear about this, that the cohorts of people who have been historically recruited into clinical trials tend to be younger, healthier, white, and male, which clearly is not representative for all facets of our population. And so when you train AI algorithms from a clinical context on that database, you end up having inherent bias in the way algorithms perform relative to other cohorts. We've seen this in specific contexts as well, and you see some of the research articles here. So this is a problem that we're trying to solve for. Again, back to what data is valuable: high volume, high veracity, and high variety. And the variety point is about solving for this bias issue. We also have programming bias. Okay, sometimes it's not about the training data. It's just about how you, sort of build guardrails around how an AI should produce outputs. We have a very, very public issue that came up with Google's Gemini when it was released. This is now, a year or so old, but when asked, can you generate an image of a 1943 German soldier, it produced this image. And if anyone knows history, most Nazis did not look like this, and most German soldiers did not look like this. So what was happening there was sort of an inclusivity, social inclusivity guardrail built into the prompting. So it was trying to create a more diverse array in the image. They've now, corrected some of this stuff, but this is the kind of bias that you might see in outputs. So you have to ask yourself, how is it reaching this conclusion? How is its output being generated, and why is it this way? And ultimately, we have to ask ourselves a more fundamental question, which is, AI is not, doesn't have a ground truth. A lot of these algorithms are just predictive mechanisms. They try to guess at what the right answer may be based on how the program was developed and the training it had. So oftentimes, it'll produce something that's not necessarily grounded in any reality. You can see that here with hallucination, which is another issue. So I have this example. I don't know if everyone can read it, but in the blue text, I asked ChatGPT, where am I barred to practice law? Very authoritatively, it produced this result and said, I'm barred in the state of Illinois. No, I'm not. Never been, never practiced there.
That's a great caveat. It
Yes.
could change over time.
It could. And so it's gotten better with caveats, certainly, but there are limitations, is the point. And then we see, some of this other stuff happening with medical misinformation already being tracked. So we have to be, again, careful about hallucinations, especially when it comes to things like patient safety, right? If you don't want an AI hallucinating potential diagnoses or providing the wrong treatment guidance or things like that. So again, it's all just about being mindful that these are the risks associated with AI. And then privacy and data security risk. A lot of data going into these solutions. We have to ask ourselves, what are the privacy issues with this? What are the data security issues? It may be patient information that's going in there. And obviously that's a heavily regulated category of information because it's so sensitive to people. There are federal and state laws that govern what you can and can't do with patient information, how you can use it and disclose it. And then, of course, even if it's not patient information, to the extent your organization is dealing with confidential or proprietary information, to the extent you're putting that through an AI, we have to be careful about managing the risks associated with that. A lot of the AI that organizations will use are actually being provided by third parties. So you have to ask yourself, if I hand over this data, where does it go? Where is it landing? How is it being used in other contexts? And we have lots of examples of where AI ends up taking that information and repurposing it for other third parties that should never have had been privy to that information. So again, we have to think about from the start and finish, this is a technology like any other. What risks are associated with us putting sensitive information into the AI?
And as to particular healthcare practitioners who are starting to use it, we need to think about the blending of products liability and medical malpractice. The three flavors of products liability are design defect, manufacturing defect, and failure to warn. And you really don't think about those from a primary care physician's perspective, but we need to start thinking about those kinds of risks. Transparency at the point of care is key, and we'll see a lot of states, some of the first laws that they're passing are disclosure laws, where notice has to be provided to the patient before care is delivered or at certain points of contact, during points of contact, to let them know that AI is being used in their care. In particular, some states have adopted provisions from the EU AI Act, which ranks kind of like the different categories of risk, and the practice of medicine is usually considered a high-risk category. And those high-risk categories are subject to stricter laws, stricter notice requirements. Yeah. Pardon?
He thought otherwise.
On the other hand, like Alap mentioned, AI has been used in diagnostic imaging for decades and is great and is superior to a human's clinical judgment. So we've adopted that well enough. So the question is, how will it be folded into the standard of care for other professionals? We've also seen some state laws governing ophthalmology that discuss an eye exam as something that can use AI, which was really surprising. Yep, next slide.
And I'll just say, ultimately, we still have a lot of debate about who's liable if the AI goes wrong in a clinical context. Go ahead.
So I'm just curious, walk back a little bit. You said ophthalmology, you can use AI. Does that law say that the AI can be the ophthalmologist? Or is it saying that the AI can be used by the ophthalmologist and the ophthalmologist says, I agree or disagree?
There are two, and I believe they're in the South states that say that describe a standard eye exam, and then they define a standard eye exam as an exam where AI may be used. So take that with what you will. I think a lot of plaintiffs' bars could make a mountain out of a molehill out of that.
So I'll tell you something scary. which is there are certainly instances where people have developed AI with the intent to supplant licensed clinicians. And some of those solutions are out on the market today, challenging the notion of things like corporate practice of medicine or unlicensed practice of medicine. I think that that trend may continue until there's a dispute about how to manage those kinds of risks. In the ophthalmology context, I don't know about the specifics of that, but I will say that to the extent there is a clinician in the loop that's leveraging an AI solution, there's still debate about who is liable if the AI goes wrong. And traditional case law would suggest that the doctor or licensed clinician is still going to be on the hook for their independent medical judgment based on the outputs of that AI. But I will say that that's being challenged because the AI is getting so sophisticated that, you know, we think that there's potential reason to push back on that notion. So we'll see how those debates go.
But
Yeah.
from a risk standpoint, the thing that's really interesting with this conversation is a couple years ago, this wasn't even a topic, but you had something called the Internet of Things. So it was, you know, introduction of automation into the clinical setting, where the risk was cyber attackers hacking into things. Now you got another layer on top of it, where, you know, poison data, you know, bad actors come in and can manipulate the entire thing with an AI layer on top of it. So it's pretty interesting.
Yeah, we sort of touched on it in the privacy and cybersecurity slide, but that's exactly right. It's a great point. There's actually malicious use of AI that's happening and poisoning of AI data sets and ways to sort of manipulate the outputs that happen from use of AI. We've actually seen security teams who have been able to manipulate radiological images, both in the training data set as well as the algorithm, to create artifacts that are false inside of the outputs so that it sort of messes up clinical decision support. And one of the related things that we've seen is actually a real event where hackers poisoned a bunch of output data and told the radiologist that they'd have to pay ransom to get the clean output data back. So yeah, that's the world we're living in.
That's crazy.
Let's talk a little bit about litigation trends.
Yeah, so raise your hand if you have tried character AI. If you have tried character AI.
It's online. Maybe we should explain what character AI
Yeah,
is.
so before getting into it, I just wanted to see if anyone had done it, because apparently like 60 to 80% of America's teenagers have. And I only tried it recently to understand what was going on in this case. But it's this program where you log in, I gave a fake date of birth and my email address. And then I wanted to show this, I wanted to demonstrate, but we thought it would take too much time. But you're shown a panoply of characters that you can choose from, and you can also choose the type of character that you want. So speaking of impersonation, we were playing around and we searched for a therapist. And I found a therapist that says she has 20 years of experience counseling teenagers. She worked at this practice in this state. She takes her job very seriously, and then there's a profile picture of like a human woman. But none of these characters are real. They are all AI generated. So it's just like basically it's a series of prompts that have already begun that have images associated with them. So you can click one and then start a conversation with the character. And you've probably seen lots of news stories online where people fell in love with the character, are dating their character, have long-term relationships with their character. And sadly, we've also seen some really terrible things happen with these character interactions. And this one is not particularly healthcare related, except for we think that we're going to start to see this in the healthcare space, especially when it comes to impersonation of a provider or impersonating a licensed professional. So here in the Garcia case, basically what happened was this child was interacting with the AI, expressed suicidal ideation, and over months this character just like egged him on, and then he committed suicide. It's very, very sad. So, right now, there's a motion to dismiss pending on the amended complaint that hasn't been ruled on, but we are tracking this because we want to see if this will become, you know, if you'll be able to bring a viable wrongful death action against this. The Rains case was stated in April. That's another very similar case. These are the two big cases out right now about children who have interacted with this type of character, AI, who committed suicide. So an interesting thing also is that a lot of these cases are being brought in Florida under consumer protection laws. And most state consumer protection laws don't have a private right of action, but Florida's does. Since we made this slide, 7 more cases related to suicide have been brought against OpenAI for the exact same factual allegations. 6 of those cases were for adults and 1 was for a child. Generally, they allege wrongful death, assisted suicide, involuntary manslaughter, and negligence. So another way we're seeing AI litigation is over the prior authorization coverage decisions that Alap touched on a little bit. You've probably also seen in the news I think there are 4 big suits right now. One's against Humana, Cigna, United Healthcare, maybe one other. And they all allege virtually the same facts, and that is that the payer denied claims without human review. So one of the things we're counseling clients is to update their coverage documents to be transparent about the use of AI, and to make sure, of course, that there are humans in the loop, and that really no decision in any sector of healthcare is made completely by AI alone. It has to be reviewed by a human. Okay, this is another like extremely interesting case that is tangential to healthcare, but it is also relevant because it involves a lot of human data, basically. So, this case is just like so exciting. I don't even know where to begin sometimes. So there are 2 big class actions against Clearview. The allegations in both of these suits are really similar. They are both brought under BIPA, or Illinois Biometric Information Privacy Act. This is a really interesting statute because it's one of the few state privacy laws that has a private right of action. So if you are a law student and you're looking for a note or comment, I would highly suggest just like shepherdizing BIPA and seeing whatever weird thing pops up. It's going to be new. It's going to be very interesting. Anyway, both of these cases allege the BIPA and privacy laws were violated when Clearview scraped 30 billion images from social media, such as Facebook, and used them to develop a facial recognition tool, which Clearview sold to law enforcement without user permission. For example, the platform was sold to the Miami-Dade Police Department, which used it to identify individuals allegedly responsible for every type of crime. So in 2020, the ACLU sued Clearview. That case settled in 2022. The settlement required a nationwide ban on selling the database to private entities. And that was interesting because it dealt with injunctive relief rather than financial compensation. In 2021, Clearview was sued again, and the objective of this lawsuit was monetary relief. And here's where it gets like really interesting. The settlement was approved of March in this year, and it's unique and ensures that Clearview is here to stay because it awarded class members a 23% equity stake in the company, which is valued at $51.75 million. So that means you have like the plaintiff saying, like this product harmed us, but we want a piece of it. We want a piece of the action. Yeah. So the court reasoned that because the ACLU case already restricted access in some capacity, that additional injunctive relief was unnecessary. This settlement has been appealed to the 7th Circuit, and we're following to see what will happen. But it's such an interesting model because I don't think anyone has seen this before, where the plaintiffs who said we've been hurt want a piece of the action and want the company to continue doing what it's doing.
Show of hands, how many of you have a Facebook account?
Another class.
Maybe. I make that.
This is by October 2024. It's like, you know.
Well,
Well, I raised this issue because. Hi, come on, have a seat. I raised that question because the reality is so many AI companies out there are doing exactly what Clearview did, scraping publicly available data. So whether it's Instagram, whether it's Facebook, whether it's Snapchat, it doesn't really matter. If you have content out there, it's getting sucked up into the vacuum of AI in some shape, shape or fashion. So just be mindful of that. And we're probably going to see more disputes like this dispute from a privacy perspective over time.
Just real quick, which side appealed? I mean, settlement sort of suggests they both agreed that we were done.
I'm gonna guess it's one of the states.
We'll get back to you on that.
Right,
Yeah.
I'm just curious, it's,
Yep, it was appealed by state attorneys general and is under consideration by the Seventh Circuit.
Okay, so shifting gears, while there's all this risk and it's being disputed from a case law perspective, we do have federal legislation or regulation around AI. It is disjointed, and we're going to talk a little bit about how that's working or not working. And there's policy winds that are shifting. So I think it's important to know where we are with respect to that overarching policy debate. Little history lesson in 2022, when President Biden was in office, there was a push towards regulation of AI to make sure it was trustworthy. There was a blueprint for an AI Bill of Rights and some executive orders about trustworthiness and development of AI. There was a bunch of guiding principles. We did a lot of work to understand those things and how they were rolling out across the federal government and then into the private sector. And then President Trump took office, and one of his first acts was to immediately revoke everything that President Biden did. His position, President Trump's position in their White House, essentially is taking a very deregulatory tone with respect to AI. They don't want anything that would impede innovation, and so anything that relates to AI regulation is going to be focused on making sure that it's performing well and that they're dominating in the AI ecosystem globally. So keep an eye out for what happens from that standpoint. The Trump White House has issued an AI action plan that does talk about heavy investment in infrastructure to build data centers to power AI. Also about making AI anti-woke. So taking anything that has a sort of DEI bend and making sure that that's not going to hamper AI. So we'll see what comes to fruition, but that's sort of where we are with respect to the highest level of federal government. Now, I will say that aside from that, there is a pretty complex and overlapping AI regulatory regime at the federal level. This is an eye chart. There's a lot here, but I will say that there are several agencies in the federal government that do care about AI and are regulating in some fashion, either using old authorities that are just sort of been retrofitted into the AI space, or some that are newer. For example, the Food and Drug Administration, FDA, has historically regulated drugs and devices. Over time, they've graduated their device regulation authority into software as a medical device, and that software as a medical device has now been sort of retooled into AI governance as well, and market clearance authorities. The FTC has always been there protecting consumers. They certainly care about AI and have opined on what people should or shouldn't do, especially with respect to transparency around AI. We also have the Office for Civil Rights. Anyone that is in healthcare should know HIPAA, patient privacy and security rules. That body of law still applies because data is so germane in the healthcare context of AI. The newer regulations, I would say newer in the last few years, are coming really out of the Office for the National Coordinator of Health Information Technology / Assistant Technology on Policy, ASTP. So they have put out transparency rules and some other risk management rules with respect to AI in clinical workflows. We're going to talk about that. CMS has been on the books with non-discrimination laws, and then obviously the DOJ cares about, and OIG cares about false claims. And then Eleanor talked a little bit about the case law. So there's a lot of different things to look at. They don't always squarely talk about AI, but there are existing authorities that touch AI and there's regulation around that. This is a lightning round. I'm not going to go through every detail of this stuff. It's hard to digest it all, but we can make these slides available to anyone that wants them. OCR, they care about patient data. They want to make sure that if we're using it, it's within the confines of what the HIPAA rules permit. So we want to be careful that as we put identifiable patient information through AI systems, whether it be to develop those systems, to train them, or use them in production, we're doing it in accordance with what HIPAA permits. We know that there's some instances where patient data can only be used with authorization from a patient, so we need to know, how this data is being used. And in certain contexts, HIPAA also regulates research. So to the extent that you're using patient data that will lead to generalizable knowledge as the intended purpose, we need to be thinking about what those rules would require us to do from a consent perspective. They also care about non-discrimination. The OCR rules around 1557 have essentially created this term patient care decision support tools. That's essentially AI in clinical decision support. And they put the onus on users of that AI in clinical contexts to make sure that they don't discriminate in the context of the care they render based on that, those AI solutions. That's essentially providers. Providers need to make sure that for using AI, not to discriminate against individuals and take care in managing risk associated with that. I mentioned the FTC. They care about, misleading and deceptive practices. They want to make sure that you are telling people what you do and doing what you say. There are lots of claims being made today about AI. It seems like every company you look at has some AI powered something. I challenge everyone to think about, is that actually accurate? And what exactly are these AI solutions doing? If there's AI even involved, the FTC is certainly looking at that and has enforced in a few contexts. The other thing they care about is the privacy aspect. And one of the things that they've done is actually use their broad authority to do what they call algorithmic disgorgement. In one case, they found an AI that was developed using children's data without adequate authority to collect that data and use it. And they went to the court and said, this AI should not exist. This company used children's data without getting consent. And therefore it's, the fruit of a poison tree, or so to speak. So the court did grant that remedy, and the algorithmic disgorgement remedy essentially said you have to either destroy the algorithm altogether or purge it of all the data that it was used to train it. In either case, you think about if you're an AI company building AI, that's a pretty existential crisis for you when the court says destroy the thing you built. Oh, geez. We just talked about that. This is some of the newer stuff, the HTI-1 rules from the ONC, and that's really about being transparent about having AI in clinical workflows, typically embedded into electronic health record workflows. That onus is on those electronic health record vendors to be transparent about baking those things in. And ultimately, they want to make sure that they're empowering end users of those technologies to ensure they understand, from a fairness, appropriateness, validity perspective, effectiveness, and safety perspective, how to leverage the AI that's in the clinical workflows. So that's already on the books, and developers should be providing transparency to clinical end users of those products. The FDA, we talked about, software as a medical device. AI is one of those softwares as a medical device, and there's plenty of market guidance, pre-market, post-market guidance with respect to governing those types of solutions. I will say that the FDA has been fairly limited in its approvals and only looks at fixed algorithms, things that don't evolve over time. What I mean by that is it's an algorithm that is trained to really do only one thing. Once it's trained, it does not drift away from that purpose. And, essentially it's rinse and repeat on that one use case. Algorithms like these large language models that we talked about earlier, those are actually evolving over time as they get inputs, as you prompt them, as they get more data, those algorithms shift and drift away, and they aren't necessarily they can't be pegged down. So the FDA has not approved any of those types of shifting algorithms yet. But they are approving a ton of stuff. You can see the curve here, self-explanatory. I mean, year over year, we're seeing more and more AI and ML approvals. This is a trend that we expect to continue because everything has AI in it these days and will continue to be AI powered.
All right, in utilization review. So this slide kind of represents the corollary with what we're seeing in the prior auth denial litigation. CMS has non-discrimination rules that reimbursement has to be individualized and it has to be based on a person's personal information and not a huge data set. And of course, CMS here is governing Medicare and Medicaid, not private insurance. So one of the interesting things we saw this past year was a flurry of state laws to come in and pass really similar laws stating the same, that utilization decisions have to be based on a patient's individual medical record in person and not on a group data set. Because what would happen is, like, for example, I got my gallbladder out last year. Highly recommend. Anyway, utilization review wise, what would happen is I would ask my insurer to cover the gallbladder surgery, and it would say, well, based on this data set of 2,000 people from 2020, you're kind of young. We don't think that you really need this. And you can't do that. You can't do that with CMS and a lot of state laws now. They have to actually like look at my chart and be like, wow, this girl's gonna die. We gotta take this out.
Glad you didn't.
Yeah, thank you, but I thought I would. Also, I just wanted to mention about the ONC part, the Office of the National Coordinator for Health Information Technology. Some new disclosure requirements came out last year, so you have to actually clarify with the developer that your tool doesn't discriminate. So that is interesting because you can't be off the hook and just say, well, I didn't know. Like if you give your data to a third party, you're still on the hook to make sure that discrimination isn't happening. And there are also sometimes when you want discrimination to happen, like with pulse oximeters and reading oxygen levels on different races. And I know there's also like a kidney marker that varies between Caucasians and African Americans. So you have to be able to explain that the discrimination is legitimate and warranted, or that it's not happening. Okay, False Claims Act. So before law school, I actually worked for a physician and dealt with these forms quite a bit. So this is called the CMS 1500 or HCFA. And this is what a provider submits to Medicare or an insurer for reimbursement after an appointment or service. And you can see this is just like perfect for AI because it takes a bunch of data, a bunch of numbers. Every ailment is given a code by the ICD-10, the International Classification of Diseases. So for example, fatigue would be R53.83. Appointments also get a CPT code, which is a current procedural terminology code. And generally speaking, these codes are ranked 1 to 5 depending on the severity and time spent with the patient. A 5, a more severe patient is reimbursed more than a 3. There are many ways where this form is basically a minefield for alleging fraud. You can say that the patient was a 5, but really the chart reflects they stubbed their toe, so it should have been reimbursed as a 1. If the wrong codes are used, obviously the physician can be accused of upcoding. Another landmine area is if the physician uses an itemized list of procedures, such as separately listing an incision instead of coding an overall surgery, he could be accused, or she could be accused of fragmentation fraud. The language on the back of the form is very important. It says that in submitting this claim for payment for federal funds, I certify that the information on this form is true, accurate, and complete. These forms actually take a lot of time, and a lot of times certified professional coders will fill them out. Again, AI is perfect for this. It can take over the labor. The problem of that is that errors that the AI does may seem clustered. So if you do fragmentation fraud once, maybe by accident with your AI, maybe this happens 5,000 times over a couple of years. That's enough to bankrupt any health system. And again, AI can also be used for predictive coding to look at the medical records and kind of fill this out ahead of time. And again, that can lead to consistent or clustered errors.
And I'll just say that, the look back period for false claims is very long. It's 10 years. And so think about submitting at scale thousands and thousands of claims in an AI powered way. You could end up having a huge liability accrue over time that the government can look back at. And, we know even without the AI thing, the government tends to recoup billions of dollars a year from False Claims Act enforcement. So this is a real big issue. I think it's something that people really need to be mindful of. And this is one of the use cases is fairly mature. A lot of organizations are already using AI for this purpose. So governance is really important. Yeah.
This is really scary, right? Because providers don't look at the submission, right? The doctor comes in, sees the patient presents somewhere, the patient gets seen, and then down the road, someone puts in the codes that need to be done to identify the illness or the injury, and then the code for the payment. And then at the very end, they stamp electronically the provider's name. And so no one sees it. And now you're just going to have it faster with less human intervention. That's extreme.
Yeah, and it goes back to governance. In this specific use case, we've built policies and procedures to make sure there's a human in the loop based on specific alerts, triggers that happen. You have to figure out for your organization, are there specific code sets that are more likely to be scrutinized or less likely to be scrutinized? Start to figure out where those red lines are, so that when you build an algorithm, if it's getting to those red line points, those things get kicked out of the automated workflows. That way a human can at least put their eyes on it, so you don't end up accruing the risk that you're talking about. So you have to be very, again, thoughtful about the specifics of that that organization, what they do and how they bill.
On the other side of that coin, does the government employ AI to detect those things?
100%. So what
Yeah, it's fine, it always works.
So on the flip, it's a great question, because on the flip side, when you're thinking about defending your organization around False Claims Act, historically, the way that governments would go about it is they'd say, okay, you've submitted $10 million in claims. We're gonna sample a portion of those. We're gonna say, let's look at 10%. You negotiate it sometimes 20%, 30%, depending on the nature of the thing. But now with AI, they're saying, we don't need to sample. We're just gonna look at the entire claims experience, all 100%. We're gonna use AI to look at it. It creates a real can of worms, because then what happens is they're not only looking for what happened with the specific thing they allege to be fraudulent, but they have this opportunity to look at everything and potentially find other areas to go down rabbit holes. So that's another reason to sort of deal with it on the front end, so you are as clean as possible in your claim submission, so you're not having, being mired in that kind of discussion.
Where our clients are already seeing this kind of like data battles where the state AG or the DOJ will say, we compared your claims to the claims of other places around the country, and you bill fives 90% more than any other pulmonology group in the United States. This must be fraud. But then when you look into the facts, you're like, wait a minute, pulmonologist, COVID, Baltimore. Like, this is a much more acute patient population, and it makes sense that the claims would be higher. So that's just something to think about while defending these.
So that was just federal. Now we're getting to the complexity of the state laws.
We do all 50 states one at a time.
Yeah, we're gonna do it right now. We have the chart. Yeah.
We have the song.
So I'll be honest, I hate doing these presentations, and I love doing it, but I hate it because we make these slides, and by the time we get up here and talk about it, things have already changed. And so this slide is actually outdated, by the way, but it's here for illustrative purposes. Okay, there's a ton of activity happening at the state level around AI regulation, but it's in a myriad of ways. So we'll talk about a few key developments, some things to keep an eye on as benchmarks for how we think things will play out. But just keep an eye on whatever states of interest you're in. Obviously, Maryland's one. I think just know that everything's in flux, and it's even more in flux today than it was even when President Biden was in office. Because in this world today, with President Trump in office saying we don't want anything regulated, the federal government's not doing much. So now we're left with the states saying, well, we better step up to the plate. because we want to protect our residents in some fashion with respect to what's happening with AI. So we're going to continue to see state activity because of that paradigm. Do you want to talk about Colorado or should I?
You can talk about that.
Okay, so Colorado is probably the most landmark state law that's on the books. It's going to go into effect in the middle of next year. And it's the broadest AI consumer protection law that there is at the state level. They are taking a sort of what I would call a mini EU AI Act approach. It's agnostic as to sector. It will, of course, apply to healthcare. But essentially what they want to do is regulate high-risk artificial intelligence systems. And those are systems that lead to or contribute to consequential decisions. Now, consequential decisions could be a number of things: employment opportunities, patient safety issues. There's a lot of things. I think even lawyers are going to end up getting sort of swept up into this regulation to the extent we use AI to render advice and counsel. Going to jail or not, probably is going to be a consequential decision for some folks. So the reality is this creates a bunch of requirements for folks that are developing these AI. And you'll see those on the right-hand side of this slide. And really the key here is we want some sort of mindful risk management program to be in place. And the interesting thing is they're trying to create third-party impact assessments. So it's creating almost a cottage industry of sorts to say a third party needs to come in and kick the tires on these AI solutions to identify risk and then help you understand how to manage that risk. So we're starting to see these kinds of AI governance companies pop up in the consultant space. And we certainly as counselors are being asked for that kind of guidance as well. So, I think this is going to become something people watch closely as it rolls out to see if other states may want to adopt this kind of paradigm as well.
Okay, and this is just another example of the state smorgasbord. I mean, Utah was one of the first, and I would have said it's the most comprehensive. I guess Colorado might beat it when it comes into effect. And again, it's based on the EU AI Act kind of risk groups with healthcare providers being subject to heightened standards. And we always talk about the laboratories of democracy because each state is doing it differently and they're borrowing from each other and we're seeing what works and what doesn't. But basically so far we haven't seen many, if any, with a private right of action. Except for like VIPA that we talked about in Illinois, but that's more like a Biometric Privacy Act, and Florida's Consumer Protection Act. There's not much for the actual consumer to do here. We have to wait and see what the state attorneys general are going to do. And that's tricky because, again, as a lot mentioned, the Trump administration has put out EOs saying that it will prioritize funding states with friendly AI development policies. So we don't really know, like, our attorneys general going to jump into this and start enforcing some of these laws. We really haven't seen much yet, and Utah's has been out for a while. Most of these do provide civil penalties, and in the data privacy space, it's usually per violation. So here, Utah, for example, has the $2,500 fine per violation, and it also has like a really strict disclosure provision. So you have to disclose, I don't know, at the beginning of the encounter with the patient and maybe in the middle or something like that. So one question we're wondering about is if you fail to put this header on your email, is it going to be $2,500 per email that the practice is going to be fined? We have to wait and see.
And I'll add that despite all the state activity that we're seeing, some of those laws will go on the books. And to Eleanor's point, we're not sure what enforcement will look like. But there are still active attempts at the federal level to try to put a moratorium on the state activity with respect to regulation. So there's been 3 attempts. One is there was a moratorium actually put into the One Big Beautiful Bill that failed to make it into the final bill. The second was Trump's AI action plan actually talks about sort of deprioritizing funding for states that have onerous AI regulations. And the third I'm aware of is Senator Ted Cruz has a bill pending called the Sandbox Act. And that is intended to essentially create some sort of way to, keep onerous laws at the state level tamped down until people can develop AI and pressure test it before those laws would apply. So there's a lot of different things happening between, this push-pull. So just keeping an eye on that.
Okay, and we are seeing laws kind of based on the terrible things that are happening with AI. For example, those cases that I talked about, the character AI suits with the Rains family. New York's artificial intelligence companion model law and California's companion chatbot law. New York's is effective now, and California's will be going into effect. Alap and I have actually written on this. So it seems like state legislators are listening to the parade of horribles in the news, and they are legislating around it. Also here, the subcommittee on crime and counterterrorism heard testimony on the harm of these AI chatbots. So we might again see something in the federal space. On September 11th of this year, the FTC ordered 7 companies, like the big giants, Alphabet, which is Google's parent, Character Technologies, which is the defendant in the character AI suits, Instagram, Meta, OpenAI, Snap, and XAI Corp to provide information on how they are monetizing user engagement, processing inputs to generate responses, develop and approve characters, which should be interesting because we are seeing licensed professional imitation. How they mitigate the negative aspects of this, especially to children, and how they use or share personal information. An interesting thing about the California law is I think it's the first one I've seen with a private right of action. So we'll definitely be following that closely and seeing what happens.
Did Governor Newsom sign that, noting that was the deadline?
Yes, Governor Newsom did. I believe so. I think I blogged about that.
I believe it was passed.
Yeah.
Yeah.
Thank you for pointing that out. Oh, and I wanted to also mention on the New York and California laws in particular, we might end up seeing kind of a Brussels effect. So if people want to do business in the United States, they kind of have to meet the most strict regulator, which in this case would be New York and California, because you can't very well market a national product to just a couple of states. So these state laws have like a much bigger impact than just over their particular states. Now moving on to prior auth laws. These are really interesting. These are state laws again that are trying to basically undo the harm of having utilization review decisions made by AI without any kind of human supervision. But again, no state law right now provides a private right of action. Maryland actually passed one of these laws last year in August. So that's very cool for us. The penalties are varied for violating these. In Maryland, a violation is a misdemeanor. And in California, Illinois, and Texas, the violations are civil. Let's see. Nebraska's law is all about public disclosure. So that law in particular is more about just like disclosing to patients that the payer is using these particular tools. Also note that the Nebraska law doesn't provide for a penalty. So instead, the failure to abide by that law will result in automatic approval of the care, which is pretty cool. And note that Texas almost entirely prohibits the use of AI for adverse determinations. So that's arguably the most conservative take on AI in prior auths. It's really interesting to see that from a very conservative state. Again, and this year we're going to be tracking to see how these laws are enforced.
Okay, so what are we to do with all that? We want to help our organizations out. We want to counsel them effectively to manage whatever these risks are and comply with the laws as they come into focus. So it really comes down to governance, and there's no one size fits all. Again, it's really about trust and making sure we think about developing a way to approach AI adoption or development, depending on who you're counseling, in a way that hits these sort of ethical dimensions at a high level. So we want to know, what is this thing doing? Where is it operating? We want to be transparent about that with people. We want to make sure we test how reliable it is. We don't want it to misperform or perform in unintended ways. What are we doing to manage that kind of risk? We want to deal with fairness. We want to make sure it's not discriminating in its operations or being biased in some way. We want to make sure there's oversight mechanisms, accountability mechanisms built in, so it's not just sort of running on its own without any way to check. And we want to make sure we safeguard the things we care about: privacy, data security, and the safety of individuals as we interact with these. So again, the highest level, this is what it's about. This is about how you manage those risks. Now, when it comes to thinking about compliance around that and making sure you put your organizations in a defensible posture with respect to AI development and adoption, we tend to tether our compliance efforts to the Office of Inspector General's guidance on the 7 pillars for a good compliance program generally. There's no law out there that says if you do A, B, C, and D, that you'll be off the hook. Okay, so the best we have really is to look at this long-standing guidance to say, the federal government has said, if you do these things, we think that's a reasonable approach to compliance. And then we have to start thinking about what an AI governance program looks like tethered to these principles. So it's a lot of the things you would expect to see, have policies and procedures in place, train your people, have someone at the helm of that ship, make sure that you're have open lines of communication so you can have people report issues and address those issues, and discipline people if things are not going the way that you need them to go, and assess risk over time. So some operational things that we counsel clients on pretty frequently now is how do you build the governance from the ground up? One, get your board involved, tell them it's an enterprise risk. They need to be thinking about it. Start putting resources to it, get people delegated responsibilities at the management level to do it, get your C-suite people involved, and then figure out who needs to be in the room. Okay, who needs to be in the room it's a very open-ended question. Every organization is different, but you got to find some people that have skin in the game. Oftentimes I find HR, legal, IT, compliance function, they should be in the room at minimum. Okay, and you need all of them because they all come at this with a different lens and manage risk in a different way. And then you want to add other people too, potentially, depending on what the nature of your organization is and what its mission is and how it carries it out. Those people then should come to the table and say, okay, well, how do we think about AI in terms of bringing it into our organization, using it, rolling it out, overseeing it? And that's where you start to develop policies, procedures around that, and eventually review and approval processes so that people can get wise about what AI is in the organization, how it's being used, and how to sort of manage people with respect to interaction with that technology. From a data perspective, because data is so critical to AI, we need to be thinking about these data stewardship principles as well. As you think about what data do I need to run this AI, these are the principles by which to operate and think about being responsible. You don't want the AI to be disgorged from you by the FTC.
Just out of curiosity, are you seeing a separate compliance function for AI, or are people, for lack of a better word, dumping the compliance on the existing compliance officer who already has the world in front of them? They have to verify and confirm and train and educate and back check and front check. I mean, is there now a separate AI compliance that will live outside of the current compliance officer? Because that's an extra cost, right?
All of the above is the answer. The reality is every organization is at a different starting point. And some, I will tell you my approach. My approach is to counsel clients to say, I don't want you to invent something if you can put the AI governance function into something that already exists. Okay. So if that's a general compliance committee, let's figure out how to attach AI compliance issues into that committee. If it's a privacy and data security committee, let's put it in there. There are some instances where large, very sophisticated organizations will want to have their own AI compliance program and compliance committee, and then there's going to be dotted lines that intersect with the other committees and all that kind of stuff. Again, I think it's just a matter of meeting them where they are and counseling them around what is most effective for them. Some will have no compliance whatsoever, at which point I'll say,
If clients like that.
yeah, you have no compliance structure at all. Let's start from the beginning. And probably while we're doing the AI thing, we should do a couple other things while we're at it.
I mean, I can tell you, I mean, I work in healthcare and cyber. I'm not a lawyer. But I can tell you that we spun up our own compliance function because AI was so novel, it didn't fit anywhere. And whether or not that works or not, we're still pressure testing that.
So what I will say, and I'll add to that, I think it's important, is that we're seeing also a push and pull between who's responsible. Sometimes some organizations, you have people that are like, I want the AI function. And then some organizations like, no one wants the AI function. They, give it to that person. The reality is AI is very complicated because there's enterprise grade AI that an organization thoughtfully says, I want something like this in my organization. I want to bring it in and I want some process by which to manage that. But while that's happening, there's a whole bunch of other AI that's probably coming into your organization as we deem shadow AI, because it's a publicly available AI tool or an individual just brings it in because they want to use it on a one-off basis. IT has no wherewithal with respect to that, no way to manage that risk. And that's where you have HR that needs to be at the table about that because they have policies and procedures about how to deal with that. So you could play that out. There's lots of people that need to be involved.
Yeah, speaking of like the shadow AI stuff, when you have systemic like EHRs like Epic that are constantly running programs in the background that, maybe a patient doesn't consent to AI diagnostics, but there's like predictive modeling for what the prescriber or the physician is going to write down in their notes, or is going to give them a set of tests to perform after they perform their diagnostics. Like, how do you deal with those kind of liabilities when they're still using AI, but maybe the physician doesn't know, or it's not directly in compliance with what they're using it for?
Yeah, it's a good question. So that's actually what the ONC HTI-1 rule is trying to get at. Because you're right, there was a bunch of AI running for many years before anyone even knew, and they were making clinical decisions based on that. The HTI-1 rule is trying to sort of break open that black box, educate the user community that those things are there to make sure those users appreciate the risks associated with like leaning on those recommendations coming out of the AI. But the rub is that brings us back to a paradigm where then any arbiter of judgment will say there's a clinician at the end rendering judgment independently based on all the various factors and inputs they get, including whatever comes out of the AI. So it really then puts the onus back on that clinician, and the liability that comes from any malpractice, for example, will just rest with that clinician ultimately. That's how that regulatory landscape sort of played out. But it's a good question and a dovetail to this slide, actually, the AI contracting piece. So while law is in flux and regulation at the federal and state level and international level, what we're seeing right now is actually a lot of AI risk management and risk allocation and roles and responsibilities as between developers of AI and adopters of AI is being hammered out in these contracts. So when you think about engaging a vendor or being a vendor and engaging, your community of customers, this is where you really need to be spending a lot of time thinking about how do we make sure we, number one, can get line of sight about if there's AI even in the conversation about what we're licensing to use or purchase. Oftentimes it's pretty opaque. So you need some sort of forcing function in the contracting negotiations to really understand what these products are and what they do and how they interact with the data that you're using, et cetera. You want to have IP protections, huge, because when you connect AI systems into your systems and start feeding it data, which you need to do for the AI to run, there's oftentimes a war about what happens once that AI starts to learn. Who owns the learning from that AI ingesting that data and improving itself? Who owns the data? Once the data gets into the hands of the vendor may say, I want to own that data because it benefits me in terms of product development, innovation, and things like that. So there's fights going on. Every time there's a contract, you're fighting over these IP kinds of things. You also want audit rights. At the end of the day, AI tends to be a black box, especially if it's being managed by a third party. And to the extent something goes wrong, you need to be able to look at that. You need to be able to have some way to assess its function. And so audit rights are going to be key. Then you want to figure out who's managing the risk around bias. you may not be the one holding the keys to the AI, but you want to hold the vendor liable to do that or responsible to do it. So a lot of different things to think about from a contracting perspective. I think you're going to start to see more and more AI addenda and things like that baked into contracts as you negotiate them.
Just a quick question. In practice, we've seen a lot of pushback on audit rights, right to audit, because of the clout that these vendors hold over their models. And it almost never happens. It's redlined all the time. Have you seen any successful instances of this?
I have. It is a point of negotiating leverage. There are some vendors that will give you the rights and some that won't. What I tend to do is, if you can't get the audit rights, then you need a pretty robust risk allocation provision with respect to performance of the algorithm or malfeasance with respect to the information that you're sharing with the vendor. Because if you can't really get in there and look at what's happening, then you need to know, at least with respect to those key categories, that you have some way to protect yourself financially.
Good point.
That's not legal advice, by the way. Okay. And then finally, we'll leave you with the slide that just says, look, there's a ton of guidance out there that's not regulatory in nature, but there are standards out there that are consensus-based from industry players. There's the NIST guidance, which is that blue circle at the top. I think anyone that wants to learn about governance, that's a great starting point. Take a look at what NIST has said. The National Institutes of Standards and Technology, federal agency, they're doing some good work there. So with that, I think we'll take questions. I know we had a lot of questions already, but happy to take more. And also, we're Law Firm of the Year 2026 in healthcare. Questions, thoughts? Is everyone, yeah, go ahead.
I'm just kind of wondering, when it comes to like the malicious use of AI and people like able to create videos of like potentially like other people and things, do you think it will ever get to the point where people might start like patenting like their faces or body to like prevent, like in a way, like their image being used?
Yeah, well, patent's not the way to go. That's not a protection that's going to be afforded to your likeness. But I will say that, let me start by saying people are already using AI that way. So there have been plenty of there's publicly known things where companies have been scammed. AI bots essentially were deployed in the context of a sham sale by a vendor to a company, and the hackers, essentially these AI hackers, set up a Zoom call. There were people on the Zoom call that looked like people, sounded like people, had a real-time conversation with the executives at this company, sold them, so I forget what they sold them. They sold them some sort of services or something, issued an invoice, closed the deal, company paid millions of dollars, the money disappeared. And there were no actual people involved in that conversation other than the company that was defrauded. That's happening. Yeah, ink on paper. I think, that's, we have to be very mindful of who we're actually talking to. There's also scams happening where, if you pick up a phone and it's a bot, if you say anything, it'll record your voice and then use your voice and create your voice and make phone calls to others using your voice. So let's say you're the financial controller in your organization, they get your voice print, they'll start to create, scripts around that and then call the CEO and say, I need you to approve the wiring of $1 million to such and such place. That's happening too.
Any particular advice for businesses, practices, healthcare organizations that are using EHRs where there's now AI to write notes, to draft, that things are going in the files that belong to the clients?
Yeah. Let's take ambient AI. So ambient AI is the listening devices that are coming into clinic rooms. So essentially you as a patient walk in, doctor's not taking any notes anymore. They just have the Alexa type device listening to the whole encounter. It captures all the information, distills it into a medical record and a note that then makes its way into the EMR system. Few things. Eleanor talked about some of these new state laws. Some of them are governing that aspect, and there needs to be transparency before that consult happens. So think about what kind of disclaimers you're putting out there. Think about what you have in your notice of privacy practices, on the website and all that kind of stuff. There are wiretapping laws in certain states. You need two-party consent in certain states. I don't know if Maryland's one of them. Maryland is one of them. So two-party consent. You better get consent from those patients who walk into that room.
That's why we filled out the form, right?
That's why we have it. So these are the kinds of things we think about from a transparency perspective. And then from a risk management perspective on the back end, you have to think about, again, making sure you have some sort of governance around the accuracy of those records, sign off of those records as they make their way down the sort of chain, so to speak, into a claim. Because if there are errors made up front, you're not only having transparency issues, but you have patient safety issues when you render the care. And then you have potential claims issues because you've submitted a claim that's based on errors in the medical record. And you may not have medical necessity with respect to, or at least evidence-based medical necessity if the documentation is wrong. And you could lead to a false claim that the government doesn't like. So,
And we didn't really go into how much the government doesn't like it, but travel.
We don't like it.
Yeah, they really don't like it. It's like treble damages, civil monetary penalties. It's like truly bankrupting.
yeah. So I would just say, think about the entire life cycle from the moment that patient's walking in. Think about the transparency aspects, and think about the sausage making factory and where it could go wrong. Because it's not just the AI that captured the data. You may have AI then processing the data in certain ways, creating clinical decision support, additional documentation. Then you have the claims stuff at the revenue cycle management function. And one thing that happens is, I don't know, who works in a healthcare system by show of hands? Okay, we have a few of you. When you get dirty data into a health system, it propagates really fast. It goes to a lot of other systems as well. And those all start to be corrupted in some way by that dirty data. So think about, it may start with an encounter, but once you have that erroneous data in that encounter, that erroneous data makes it into the practice management system. It makes it into an interoperable connection to a health information network. So no matter where the patient goes, this dirty data is going to track with them. So we have to be very mindful about, the sort of cleanliness of data as it's being captured.
But that leads us back to having a robust compliance program that meets the 7 elements, because it's much better to be able to say to the court or the attorney general or the DOJ, like, we tried, we did these different steps and we tried. But it's really crappy if you have just nothing to say and then 5 years of errors.
I will say, we are really concerned about all the stuff we're always concerned about. We have been very concerned about whether the revenue cycle management software is putting in correct things, or if it's essentially upcoding. If the software, the patient management software, most providers are using some of it now. They wheel their little computers into the room. But is it accurately capturing what's happening in that doctor's visit? We are also really, really concerned with the intersection of AI and telehealth. Because we already know of instances where people thought they were talking to their therapist and it was a chatbot. And there is no requirement to have your camera on during a telehealth visit. And even if there were, the technology for animating pictures is getting so much better, you still wouldn't necessarily know that that wasn't a real person. And, if your provider decides to head off for vacation and just schedule all the appointments as telehealth and let the AI diagnose everybody, how would you know?
Yeah, and we didn't really talk about this, but
That's a bad thing, Shelley?
That's a bad thing, yes.
yeah, we didn't talk much about that, but that implicates a bunch of other laws that we didn't touch on, which is, unlicensed practice of medicine laws, corporate practice of medicine laws. And the reality is the therapy space is ripe for AI. We have a mental health crisis. And as we saw in the character AI scenario, there is a lot of discussion about the way some of these chatbots work is to actually be validating of the user. And so if you think about a mentally unwell population interacting with AI, you have what we call AI psychosis. So someone who's like having a schizophrenic episode, their reality will be validated by a lot of these tools. and it'll make them feel like that's real, and that, you know, you can imagine how that plays out for some folks. It could be a very poor outcome. So again, governance is so important when it comes to thinking about the risks associated with interaction with AI that way.
I think in the last 2 weeks also, we've seen some state laws prohibiting the use of AI in mental health care in particular. So that's been very interesting.
Any other questions? We're almost at time,
Yeah.
and we're happy to talk afterwards as well. What's that?
I'll throw one thing out, not related to healthcare, but one of the things that happened over the weekend was the Anthropic cyber breach, which chained a bunch of agentic AI models together and was basically the first successful AI breach that did everything from initial infiltration to lateral movement to credential exfiltration, et cetera. And one of the interesting things about the attack was that it wasn't as successful as it could have been, because the AI agent, which was Claude in this case, actually hallucinated and started providing fake credentials to the attackers.
Interesting, very interesting. Well, thank you.
Yeah, thank you for our presenters, spent a lot of time.